Right to Education Act and the Street Vendors Act, his current interest areas are the rule of law and the constitutional right to carry on business and trade in India. So today we're going to talk about the implications of RTI in private schools. As we all know, earlier this month, the Punjab and Haryana High Court ruled that Haryana government can take coercive actions against the private schools if they fail to comply with the Education Department under the RTI Act. And since then, there is a looming threat of closures and derecognition, which has only evoked uncertainty in the community of private schools. So we'll try to understand today with our speaker, Mr. Prashant Narang, how it goes and where do we stand today with RTI and its implication on the private schools. So, sir, as we know that previously private schools did not provide any information under the RTI on the grounds that they were not founded by the state and were outside the purview of this act. So we just want to know, why did private schools did not fall under the RTI previously and now they do?
So here we should understand that who or what kind of bodies fall under the purview of RTI Act. See, the concept of Right to Information Act is that the government or state is accountable to its citizens, right? As a private individual, I am entitled to my privacy, and therefore there is right to privacy. But government has no privacy. Government is under an obligation to provide information to its citizens, and there is a principle behind it. The principle is because the government is financed, it's funded by taxpayers' money, and therefore it owes answer to taxpayers, meaning that because everybody is a taxpayer in this country. We pay either direct taxes or indirect taxes. In fact, everybody pays indirect taxes, and therefore government is accountable to its people. This is the basic concept. This is the basic principle behind Right to Information Act. Now, if you say what kind of body, so Right to Information Act defines public authority. So any authority which is, let's say, a creation of statute or constitution or substantially financed by the government comes under the purview of Right to Information Act. And so the argument would be that because schools, especially unaided private schools, by definition, when we say unaided, meaning that they haven't received any aid or they don't receive any aid from the government, therefore they are outside the purview of Right to Information Act, which is correct. So far so good. That means that private schools shouldn't come under the purview of Right to Information Act. However, there is one provision in the Right to Information Act which is about third-party information. And third parties don't need to be government agencies necessarily, right? Third parties, in fact, they can be, let's say, private individuals or private companies or any private institutions, and to them otherwise the RTI Act is not applicable because they are not public authorities. But RTI Act says that any information which is otherwise available to a government agency or a public authority, that information may come under the purview of Right to Information Act, right? So private schools by definition are not public authorities, and so therefore they are not otherwise covered under the purview of Right to Information Act. But in some circumstances, they being third parties may be obligated to give information under the relevant provisions of RTI, under the provisions of Right to Information Act that applies to third parties.
Okay, thank you, sir. So you just talked about the unaided private schools. So it means that they are not subjected to RTI yet. That's what you meant, right?
So yeah, exactly. That's what I'm saying. That see, RTI is not directly applicable to private schools. So therefore, they are not public authorities. Therefore, RTI is not applicable. But third-party information, and I can tell you what third-party information is.
Yeah.
And if you look at Right to Information Act, it says, there is certain information which is exempted from disclosure. So for example, section 8 is about what information is exempted from disclosure. And clause D says that information which is related to commercial confidence, trade secret, or intellectual property, this sort of information is exempted from disclosure, right? However, in this case also, if the competent authority is satisfied that there is larger public interest that warrants the disclosure of such information, then this information will have to be disclosed. Similarly, Section 11 is also about third-party interest. And Section 11 also says that if any information which is asked from third party, it may be allowed if the public interest in disclosure outweighs the importance, any possible harm or injury to the interest of such third party. So the competent authority will have to make a decision based on whether there is any possible harm or injury to the interest of third party, or whether the public interest outweighs that possible harm or injury to third party. And based on that, it will decide whether the information asked from third party has to be supplied or not to be supplied. So one thing is very clear, that the state public information officer or central public information officer will reach out to third party to give a written notice to the third party, and it will hear the third party as to why third party thinks that information should not be disclosed. So it will have to hear both parties and then accordingly decide.
So what if this information which has to be disclosed, if it's in the interest of that third party, then what happens? They can decide not to disclose it?
No, so the order of the information officer will be binding. It has to make a decision based on whether, so I understand your point. You are saying that the disclosure might prejudice the interest of the third party. But if the information officer thinks that the public interest will outweigh the prejudice caused to the third party, then the information officer can order third party to disclose the information. And so the school will have to disclose the information.
Okay, so they will have to anyhow, and they are obliged to do so.
They are obliged to do so. So for example, in Delhi, there was a case, Bindu Khanna, and there I think a teacher who had a former teacher who was no longer employed with the school had asked for her employment records from the school. Now, in this case, you can see that the argument was that it's labor record, so there is public interest. And so in any case, the law also says, RTI Act also says that any information which is otherwise available to the government agency or any government department under any other law, right, that information can anyways be disclosed, right? So see, there are third party may give or may not give some information, may or may not share some information with the government. So some information that is usually shared may be under some other law. So that information in any case is shared with the government. Then there is some information which only the third party has, which is not there with the government department, with any government department, and somebody wants to know that information, right? So these are two different categories. Okay. But if there is some information which is already shared with any government department under some other law, that information will have to be shared. Of course, even before sharing that information, third party is given a chance to object, and third party can be heard whether that information should or should not be shared with the applicant. But the grounds can be very weak. I mean, if that information has already been shared with the government, that information, unless it causes some prejudice to the third party, it will have to be shared with the applicant. So the case the example that I'm giving, this, the application filed by a former teacher who wanted her employment records to be shared with her.
Yeah.
is that the court, Delhi High Court, had allowed that application because the case finally reached Delhi High Court, and the High Court said that this information will have to be shared. If you look at Delhi School Education Act and the rules under Delhi School Education Act, so the rules and the act is very clear that it needs the schools to share a lot of information with the department, with the Directorate of Education. And so that information is shared under the recognition rules, right? If you see the rules under Delhi School Education Rules, I think it's Rule 50, which is about conditions for recognition. And under that, the school has to furnish such reports and information as may be required by the director. And you know that, the labor records, especially the employment records, are also to be shared. Directorate of Education and ask for such records, because Delhi School Education Act and the rules made under are very broad. They can ask, the government can ask for any information, and also they are open to inspection by government officers. So any sort of violation, the directorate can take action. And so the directorate already collects a lot of information related to employment records, related to students, as well as related to recognition. And so therefore, the school couldn't take such a plea that this is it is confidential record. The records are not really confidential, and they are not related to intellectual property. Yeah.
So they'll just choose to actually put it in front of them totally. So, sir, let's say that it's an unaided private school and they are not substantially funded by the government, let's just say that. But as you just mentioned, like this case of Bindu Khanna's case, where some of the information, it came under the public authority, and so they were actually supposed to share the information. So what happens, something like this happens with the unaided private schools, even if they are not funded by the government? Like, what could be the cases where they are supposed to share the information?
That's right. So these private schools don't need to be funded by the government, because see, as I mentioned, funding, substantial funding, etc. This is of relevance when we talk about public authority, right? If a government funds any authority, it may not have been a creation of the government, but even if it is funded, substantially funded by government, then it should come under the purview of RTI Act. But here we are not talking about public authority. Hence, the question of any subsidy, concession, and substantial financing is irrelevant here. We are talking about third-party information, right? And third-party, I can tell you in detail, Section 11. So let's look at Section 11. Section 11 is about third-party information, right? So it says that if any public information officer is intending to disclose any information on a request which is related to third party, or which relates to or has been supplied by a third party and has been treated as confidential by the third party, right? So first of all, the public information, the PIO, has to give a written notice to third party and tell the third party that the PIO wants to disclose the information on record, and invite the third party to make a submission as to why that information should not be disclosed. Okay. Now, if it is related to commercial secret protected by law, let's say if it's intellectual property right or something like that. For example, let's say if you want to ask a school about how do they set papers or how do they teach or their pedagogy. Now the school may say it is my intellectual property rights, I don't want to disclose.
Yeah, definitely.
Okay? So that may be permitted. But if somebody argues that no, this is about public interest, so the PIO may decide if the public interest outweighs the possible harm or injury to the third party, it may still decide that the school will have to disclose that information. Now, the next thing is the third party will have opportunity to make representation against the proposed disclosure. Then the PIO will, hear and go through the representation filed by the third party, and then accordingly make a decision whether to disclose or not to disclose the information. And then third party can also make an appeal. But the principle is that if the disclosure is in public interest and that public interest outweighs the possible harm or injury, then such a disclosure will be allowed by the PIO.
So has there been any implication on any private school yet if they have not disclosed any information or they got like tangled in one?
So in the High Court of Delhi, the matter that I just cited, which is Bindu Khandam's matter, there the court went on to the extent to say that that the school may be de-recognized if it doesn't give information, which I don't understand, because the Directorate of Education can ask for records and the school will have to give records. The High Court doesn't need to make an observation here specifically in the context of Right to Information Act. So Directorate of Education in any case is free to take action against the rules under or the Act of Delhi School Education Act, whatever powers it has. So there can be consequences, because if the school is required to, or is the school is under obligation under the state education law to furnish that information to the Directorate of Education, then the Directorate of Education can take appropriate action against the school for not giving that information. Is my point clear?
Yes, sir. So you're saying in this case, the High Court was taking the decision.
So High Court kind of prompted the Directorate of Education that feel free to take action against the private school if it doesn't furnish the information.
So is it even valid that de-recognition, it comes through RTI towards schools? Because that's how it's coming in such cases.
Yeah. So it is, one can argue that it is not through RTI Act, because the school is under obligation under the Delhi School Education Act in any case to give that information. Yeah. So the Directorate of Education will approach the school to furnish information under the School Education Act, Delhi School Education Act, and then disclosure, meaning that disclosure is applicable because whatever information a government body has by virtue under any other law, that information can be disclosed.
Okay. So now, let's say now we have schools and we have parents. Because let's say that I am a parent and I am just concerned about my kid, what he or she has been taught in the school, and I'll just file an RTI and it's a private school. So there are conflicting interests then, because I am actually asking school to give me that information.
So you are right. There it raises the issue of privacy. So for example, let's say someone else wants to know about the child, right? And so then that's a case of child privacy or parental privacy. So why should someone else have information related to my child, right? And so there they can't take a plea that because the Directorate of Education can ask for any records related to child or child's academic performance or any other performance, and therefore that information should be available by virtue of a third-party information. No, that's not permissible, because the issue of child privacy and parental privacy would arise.
Okay, so so let's say that we had this case where Tamil Nadu Information Commission actually ruled that private schools, they should be covered under the RTI, and this was passed when they were sorting information relating to the safety aspects in the private schools. That was in Vellore district. So how do you think we can address such issues and make sure that our students are safe inside the premises and this implication doesn't even realize in the first come up in the first place?
So, if you look at the definition of information under Right to Education Act, Right to Information Act, if you look at Section 2, Clause F, subsection F, it says information means, of course, material in any form, records, documents, etc. In the end, it says information relating to any private body which can be accessed by a public authority under any other law for the time being in force, right? I repeat, information relating to any private body which can be accessed by a public authority under any other law for the time being in force. So this is the principle which is being applied here, even in the Delhi case, that if the Directorate of Education has any information about a school, or or any information that it can demand from the school, it can summon any record from the school under any other law, not under RTI, but some other law. And that information is information under the Right to Information Act, and that can be shared. Now, as I said, the question is that does it violate any, for example, privacy or any intellectual property rights, or let's say some other competitive position of the school. So these are some of the grounds under which the exemption may be given, but otherwise it would be difficult to argue. Now, I see your point. Also, Haryana, I think, has passed an order that private schools will be covered under RTI Act. So I am not too sure if the government can pass such a blanket order. I think private schools, like any other private agency or like any other private individual, are third parties. Right? So they are third parties and they should be treated as third parties, which means that whenever there is an RTI, then the PIU has to make a decision whether the information asked has to be disclosed or not disclosed, and they should give a chance, an opportunity to the private schools to be heard. Now, when they say that private schools are under the purview of RTI Act, what does it mean? Does it mean that they're public authority and so therefore they can't make that hearing? I mean, they can't make a representation. I think if that is the mindset, that position is incorrect. Right? Private schools should be given, should be allowed to make a representation as to why the information sought may be exempted, or should not be disclosed. That right of representation is with them under the Right to Information Act. I hope my point is clear.
Yes, sir, it's very much clear. Thank you. So here you actually talked about their rights also, like schools do have rights that they should be allowed to make their own representation here in such cases. So by now I've just understood that they should not be treated as the public authority. They should be treated as third party members.
That's right. That's right. So they are third parties and they are not public authorities. And so a blanket order that all private schools come under the purview of RTI Act will take away their right to give a representation and to object to proposed disclosure of information.
Yes, sir. Okay, thank you so much, sir, for being here with us. And this was very informative. And I hope everybody who's watching it could be a school leader, also a teacher or a principal, and they just know by now how the whole implication works, and how we are also talking about the representation here at the same time. And since sir just mentioned that it's a blanket order and the mindset should be changed with time. So, sir, thank you so much for coming aboard with us. And thank you all. If you have any questions, please shoot them in the comment box and we'll be happy to respond. And keep watching and listening to NISA Talk series, because we like to foster new conversations, and because